Number 301, Senator McCready.
Thank you, Madam Speaker. I'd like to make a motion to send, after discussion with legal counsel, I'd like to make a motion to send 301 and 302 back to committee.
On that motion to send 301 and 302 back to the committee, can the chair speak on the matter? Okay, so there being no objection, so ordered. Thank you very much, Senator. On Bill 300, recognize the Vice Speaker.
Thank you very much, Madam Speaker. I'd like to move Bill 300-32, as amended by the Committee on Education, Public Library, and Women's Affairs to the third reading, and I'd ask for a short opportunity to speak.
You may proceed, Senator.
Madam Speaker, this was probably the shortest bill that I ever introduced. It amended 3 words initially. It just added "or private hospitals." But I want to thank your committee for making the additional amendments. One, correcting the name of the new title of the Department of Mental Health and Substance Abuse to Guam Behavioral Health and Wellness Center, and including the chapter entitled that was going to be amended. The intent of this bill, Madam Speaker, is to allow graduates of the University of Guam who have received assistance to work in private hospitals on Guam after they complete their education and make it eligible for their contractual obligations that they have with the university for having received the scholarship. The statute provided for, or originally provided for a whole group of places where nurses could work, health counselors, the DOE, GCC, private clinics, and my amendment initially was just to add the 3 words "or private hospitals." And I noted I don't go on Facebook very much, Madam Speaker, but the other night I went on Facebook and I noticed a beautiful picture of a couple that was announcing their engagement. And when I read the story, it was 2 young people who are currently living in Las Vegas and have announced their engagement. And then when I read the story a little further, I realized that both of them had met and graduated from the University of Guam's nursing program. Madam Speaker, that really is a tragedy that we've trained and educated these 2 young people. They've taken the education provided for by the University of Guam and have moved off island. We should try as much as possible to make sure that our young people who come out of the University of Guam can find jobs here on Guam. And the intent of adding "or private hospitals" was to allow for the graduates of the University of Guam to accept employment at the new regional center or any other private hospitals that could be built, like maybe even the new Veterans Hospital that they're planning on building. But we've got to allow for that kind of opportunity for our graduates. The head of the nursing program at the University of Guam came and spoke in favor of it. All the testimony was very, very favorable to allow to expanded opportunities for our young people who graduate from the nursing program to fulfill their obligation for their scholarships by working on Guam and including private hospitals. So, Madam Speaker, I ask for the support of my colleagues on this one. Thank you, ma'am.
Thank you very much, Mr. Vice Speaker. Senator Yamashita on the motion.
Thank you very much, Madam Speaker, for allowing me to speak in full support of Bill number 300-32 COR. Madam Speaker, I think it's just absolutely wonderful that the University of Guam Nursing Program has succeeded to the heights that it has succeeded. Now that we have nurses who are graduating, they're unable to find jobs on our island. And that's a great testament to the support of this legislature and the government, the University of Guam, in meeting the needs of our community. Madam Speaker, about 3 weeks ago, I met with a circle of nursing, the nurses at GMH, Dean of Nursing at the University of Guam, public health folks, and we were discussing how we seem to not be able to place all of our new graduates, but we have a challenge with nurses in specialty areas and nurses with more experience. Because what happens, or what is happening right now with our nurses, is once they complete 2 or 3 years of experience, if they can, they will accept a job elsewhere, just for a different environment, just to broaden their experience. And this was all raised because Department of Labor, Greg Massey, was talking about a new policy statement about immigration, H-1B, that allows, that would allow different agencies or different states to bring in nursing under this particular status. And that's why I had the community conversation. But what resulted from that was, as we have succeeded in nurturing this nursing program, and as we have succeeded in graduating nurses who just absolutely score really well and meet all the national standards, I think maybe our next step is to find out how we can support our nurses going off island, but then coming back and filling the specialty positions and our positions that would require a little bit of seniority. But I think this is a very exciting statement for our island. We do very well. And what this bill will do is open up the doors for our nurses so they can stay here. But then I think the next step at another time is to talk about how do we grow their career ladder so they can go somewhere else but then come home where we certainly need them. I stand in full support of Bill number 300-32. Thank you, Madam Speaker.
You're welcome, Senator. On the motion? Mr. Vice Speaker. Okay, on the motion to send Bill 300-32 to the third reading file without any objection, so ordered. Bill number 303. Mr. Vice Speaker, you're recognized.
Madam Speaker, on behalf of the original sponsor and the Committee on Appropriations, I move to place Bill 303 as amended by the Committee on Appropriations, Public Debt, Legal Affairs, Retirement, Public Parks, Recreation, Historic Preservation of Land in the third reading and ask for a short opportunity to speak on the bill.
You may proceed, Senator.
Madam Speaker, the bill is an act to appropriate the sum of $1 million from the fund balance for the Guam Board of the Guam Board of Accountancy Fund to the University of Guam Endowment Foundation for the creation and implementation of the Herminia Durking and John Phillips Visiting Professor and Lecturer Program. Madam Speaker, rather than speak on my own, let me just read the statement so that everybody understands that the Board of Accountancy supports this. The testimony and from Mr. David Sanford. Hello, my name is Dave Sanford. I'm the Executive Director of the Guam Board of Accountancy. Let me preface my remarks with the fact that now that we have gotten the easy stuff out of the way, I'm just going to read the testimony in the support of the bill. My apologies from the board chair, John Ade. Anyway. The Guam Board of Accountancy fully supports Bill 303, appropriating $1 million from the Guam Board Accountancy Fund to the University of Guam Endowment Foundation for the creation and implementation of the Herminia Durking and the John Phillips Visiting Professor and Lecturer Program. This appropriation will culminate in an agency-advised endowment fund agreement, which most of us have seen and may have comments on, between the Guam Board of Accountancy and the Foundation, enabling the Guam Board of Accountancy to partner with the University of Guam to supplement UOG's accounting program. The Board of Accountancy is committed to aiding and growing the UOG accounting program to better prepare our local Guam certified public accountant candidates to excel in passing the CPA exam. As well, moving to a 150-hour education requirement for licensing, which is required throughout the United States by the other 54 jurisdictions in regulating CPAs to maintain Guam's substantial equivalency, meaning that our CPAs would be on the same footing as any CPA nationwide and can go and practice in any jurisdiction equally challenges the UOG to provide more options for students, and GBA believes that the creation of this program, driven by Guam's public government and private accounting profession leaders, is a valuable first step towards doing so. In addition, we believe that the creation of this program will encourage local businesses' contributions to this endowment to aid our community efforts in developing a resident cadre of Guam CPAs to fulfill Guam's need for future leadership. So there is no question that the $1 million from where this fund is coming from supports this, and there is only one amendment that I've been asked to make, and is to put the title before Herminia Durking, to have it read Senator Herminia Durking. She, having served several terms in this legislature, her memory should also include the fact that not only was she a great accounting professor, but she was also a member of this august body.
On the amendment to place, wherever the name's mentioned, I think it's in page 2, line 22, to add the word senator in front of Herminia Durkin. No objections, so ordered.
And in the title, Madam Speaker.
And in the title as well. Thank you. So on the title.
Thank you, Madam Speaker.
On the motion, Senator Yamashita, you recognize.
Thank you, Madam Speaker, for allowing me the opportunity to speak. Excuse me, on Bill number 303-32. I stand in full support of this. I think that any time we open up our doors to welcome visiting professors and lecturers from other institutions of higher education, does a great deal of wonder for our students here on our island. As well, Madam Speaker, the visiting professor or lecturer will go back to where he or she came from and will be able to speak about how wonderful the University of Guam is and what a great place our island is. And so it's a win-win all around. And hopefully, Madam Speaker, we'll get to a point where this is specifically for the School of Business Accountancy degree program. And hopefully what this will do is spur so that this type of programming, this type of opportunity will be found in every single program, or at least every school or college that's up there. Because again, visiting programs and visiting professors really add a different lens, really are able to magnify what we are offering to our students, and then again, they take away what a great place our island of Guam is. So I think this is great, and I absolutely support it. Thank you, Madam Speaker.
You're welcome, Senator. On the motion, any other speakers? On the motion then to send, Mr. Vice Speaker, is it okay? Motion then to send Bill 303 to the third reading file without any objections, ordered. Bill number 324, Senator Frank Uggan, Jr., you're recognized.
Buenos dias, Madam Speaker, and to all of our colleagues. Madam Speaker, I'd like to move for the placement of Bill number 324, that's 32 COR, as amended by the author, which reads, an act to add a new chapter to Chapter 1 relative to the naming of the West Hagatna Beach Park to the Inetnut Ilalahi Guahan YMLG Centennial Beach Park in honor of the Young Men's League of Guam organization in the third reading file, Madam Speaker.
Okay, you may proceed, Senator.
Thank you very much, and I'll make this fairly quick, Madam Speaker. Very recently, early part of this year, the YMLG organization has celebrated its 97th anniversary in existence, and it's the second oldest organization, civic organization here in our island community. And one of the requests that was presented at that time when a resolution was given to that organization and their leadership is the possibility of naming a beach park along the Hagatna area, Route 1, after that organization. So we initially did a bit of research, and they had asked at first for the East Hagatna Beach Park, but that's already named after the Korean Association of Guam, and it also has been adopted by that particular organization. So the good director of Parks and Rec had recommended that perhaps an alternate site should be identified, and he came up with the West Agana Beach Park, which would be west of the boat basin all the way to the park area right across the U.S. District Court. So that entire area would be the park strip that would be named after the YMLG. One of the questions I had asked initially is, if in fact we name the park after the organization, is the organization willing to adopt it and then maintain that particular strip of park area? The response was from Parks and Rec director is, allow us to be able to proceed with the adoption. You can rename the West Agana Beach Park, but we'll proceed with the agreement and the understanding between YMLG and the Department of Parks and Recreation in terms of the eventual adoption so that they can maintain and upkeep or upgrade the entire area. So that has been the nature of the discussion here. And I think it really goes back, Madam Speaker, to recognizing an organization that has promoted not only our culture, but certainly a lot of our Chamorro activities and our heritage over the course of the last 97 years. They did put this request forward, knowing full well that they will be celebrating their 100th anniversary very shortly. They wanted to put up a monument, and like I alluded to a little earlier, once the Adopt a Park Memorandum of Understanding is finalized between Parks and Rec and this organization, then eventually they would be working on maintaining it on a regular basis. So that is my request, Madam Speaker, and colleagues, if by any chance we can get your assistance and support in this endeavor. Thank you.
Welcome, Senator. On the motion, Senator Tom Adat, you're recognized.
Thank you, Madam Speaker. I certainly rise in support of the bill. One time I was a young man of Guam also, and I was a member of the YMLG. And so I certainly, now I just belong to the Inet Nunlalahin Guahan. The young Manamko. But I certainly fully support this, and I'm glad that the sponsor of the bill clarified that to the question of if then the park is going to be named after that sponsor, is the sponsor going to be responsible for the maintenance of that park, and to what extent? And my understanding then is that let the legislature do its job in authorizing the naming of that park after the organization, and then leave it to Department of Parks and Rec to work out this arrangement with the organization as to the maintenance responsibilities. And then when all that is agreed on, then they can put up their plaque and say, this is the Inet Nunlalahin Guahan Park. And so I'm satisfied with that. However, I think we still need to clarify, and it wasn't really, I know that at the public hearing there was the question about when we talk about the West Hagatnya Park, the West Hagatnya Beach Park, that would extend, that would start over here at the entrance to the wastewater treatment plant for GWA, all the way down to the parking lot just before that Tony's Bar and Grill or something. That consists of about 1, 2, 3, maybe 4 pavilions. And at the public hearing, the question was asked, so is the entire strip there going to be named after this organization, or is it just going to be the vicinity of hut number 1? And then hut number 2, 3, and 4 can be later, assigned to some other organization, and it's still not clear from here. So maybe if the author will yield and help me understand to what extent is going to be dedicated to.
Senator Agon, do you yield to the question?
Yes, thank you very much, Madam Speaker, and thank you for the good senator for asking that question. My understanding with Parks and Rec is that in this particular case, it would entail the area, the park area west of the boat basin, all the way to the park area right across the street from the U.S. District Court. So they would be able to not only maintain those facilities after the adoption, the formal adoption with Parks and Rec, but that is the entire area that is identified as the West Hagatnya Beach Park. So it's inclusive of those 3 or 4 pavilions.
Senator Ada, you still have the floor.
Okay, well then that's put on the record then that it's going to be that entire strip, and that's quite an ambitious undertaking, I think, because that's a lot of grounds to be maintained. To what extent the huts, but I'm sure the organization knows what it's getting itself into, but at least now it's on the record that what's being authorized is the entire strip. Thank you very much.
You're welcome, Senator. On the motion, Senator Morrison, you recognize.
Thank you, Madam Speaker. I certainly rise in support of this measure, and I thank the author for recognizing this organization that's been around for many years and doing good things in our community. I just want to ask if the author could yield. I looked at their committee report, and the previous speaker basically brought up something that I'm concerned about too. Is I recall that certain organizations have adopted park agreements in place with the department within that area, and I thought it would particularly be one pavilion or a certain pavilion, but I know the author also mentioned right across the district court, and I recall that park being adopted within this decade. So maybe, again, I trust the department verified their adopted park agreements and ensured that those parties who have adopted those pavilions are aware of this potential. But I see where the author is going to, and it's renaming the area, but we just want to make sure that those that were recognized for their efforts in adopting these areas are aware as well that this is being renamed, but certainly those adopted park agreements will still be in place. So maybe the author can clear that up.
Senator, do you yield to the question?
Thank you very much, Madam Speaker, and to the good senator. In this particular case, the response that came out directly from Parks and Rec is that it would entail that entire strip of park. Now, there was not any mention, and I'm glad that he brought it up, of any pre-existing agreement in terms of maintaining a shelter or maybe a couple of those shelters. So that's where the naming of that strip would reflect what is provided in this legislation. The adoption of the park and the agreement therein is where Parks and Rec and YMLG would be able to consummate that agreement, acknowledging that if in fact there's a pre-existing agreement, then they would put that and incorporate that into the adopt the park documentation. So that's where my understanding of how it would proceed forward, just in light of the information that was just shared by the speaker, but that was not shared with myself as a sponsor of this legislation, and neither was it even shared at the public hearing. And I thank you for sharing that, bringing that up.
Senator Morrison, still have the floor? You're okay? Okay. On the motion, are there any other speakers? There being none, Senator Uggan, would you like to close?
Yes, thank you very much, Madam Speaker. In light of one of the previous speakers highlighting that, in fact, he was a member of this organization, I'd like to add him as a co-sponsor,
Okay.
that he was previously a member of this organization and that he's no longer the Manhoban component. So I'd like to ask that he please be a second co-sponsor and then proceed to place it in third reading. Thank you, Madam Speaker.
The name?
Senator Tom Adda.
Okay, thank you. On that motion, without any objections, so ordered. Okay, on the motion to send 324-32 to the third reading file without any objections, so ordered. Bill number 325, Mr. Vice Speaker, you recognize.
Madam Speaker, I move to place Bill 325-32 in third reading and ask for a short opportunity to address this.
You may proceed.
Madam Speaker, this is a fairly simple bill. It's an act to add a new section relative to filing consumer complaints. This was introduced by Senator Ben, and if you read the legislative intent, it shows that the intent was to to expand on the Bill of Rights that this Guam Legislature passed as it relates to rates at the GPA and GWA, and requiring that the complaints filed at those two agencies be published on the 20th day of each month on their website, and how they were addressed. And Madam Speaker, I read from the testimony of Mr. Flores, the now retired general manager of the authority, and in it he says, in the end, Bill 25 will complement the intent of the Ratepayer Bill of Rights to further serve and empower the ratepayers of Guam and provide an avenue to ensure ratepayer voices are heard and addressed. I think that very succinctly explains the reason for this bill and the importance of it, and the reason why Senator Ben introduced it. And so I ask my colleagues that inasmuch as the Power Authority, has supported the bill and recognizes its importance, that we too recognize its importance and support this legislation. Thank you.
You're welcome. On the motion, Senator Yamashita.
Thank you very much, Madam Speaker. I stand in support of Bill number 325-32. Madam Speaker, I pose the idea of, while I support the opportunity for us ratepayers to register complaints or issues of concern, I wonder if we also want to not only have that published, but also ensure that the Commission put let me see if I understand. This is to be published on a website? Right. On a website? So to also publish the resolution of the consumer complaints. And so perhaps I would ask the author to yield to that question of, do we want to close that loop so that the concerns are raised, but we also want to know that the Commission or the agency of which has to address the Commission has actually responded to the concern. And if indeed that's what we want to do, then it would be simple enough to add that this would establish the acceptance, review, distribution, and resolution of consumer complaints. And then therefore the complaint form would also be it would be a consumer complaint and resolution report, that template.
Mr. Vice Speaker, do you yield to the question?
Yes, I do, Madam Speaker. On line 10, it reads, the date the complaint was lodged and the manner in which said complaint was addressed. On page 2.
So, okay. And so then maybe to strengthen that, then maybe on line 6, that particular policy that's going to be adopted via board resolution, that policy would establish the acceptance, review, distribution, and resolution of consumer complaints. Or is that unnecessary?
Do you yield to that question?
I have no problem with adding that. It's just strengthening it. And
So then, Madam Speaker, the amendment would be to, on line 6, to delete and, then after distribution would be comma, and then and resolution.
Okay.
Just add and resolution.
On the amendment, does anyone like to speak on it? No? Then
No
no
objection.
objections, ordered.
And then, Madam Speaker, on line 8, the consumer complaint and resolution report. Unless we are saying that consumer complaint inherently includes, or it's understood that it's also resolution.
And resolution.
Yeah.
Okay,
Thank you.
on the amendment, no objections, ordered.
And then one more, Madam Speaker, in the title of the bill. It's the act annotated relative to publishing consumer complaints and the resolution thereof.
And the resolution thereof. On the amendment, on the title, no objections, ordered.
Thank you.
Thank you. So on the motion then to send 325 to the third reading file, no objections, so ordered. 320.
Senator Tinnamunya Barnes, you're recognized on Bill 327.
Sijus Masi, Mr. Speakers and Manana Sijus. If I may at this time, I'd like to move Bill 327-32 PT.32 COR to the third reading, and if I can briefly speak about this.
Please. There being no objection.
Mr. Speaker, this Bill 327-32 COR is an act relative to amending 12 GCA, Section 5135D, to place the Gura 500 lot sale fund under the custodialship, discretion, and the purview of the Guam Housing and Urban Renewal Authority. And if I may just give you some, share some insights with you per the discussions during the public hearing. It is Gura's hope that this body support this intent to give the custodianship of the Gura 500 lot sale fund to Gura, because for them it's logical. They've been the one handling this development since its inception. The authority has been responsible for the development and disposition of the Gura 500 affordable home ownership program for the last 35 years. And as we look at time moving forward, and in this time, owners seeking to refinance their properties for improvement or sale have called upon Gura to satisfy the lease provisions based on the law. Out of the 500 units, Mr. Speaker, 500 homes, there is 89 houses left from the original 500 leases outstanding today. And Gura has expended an estimated 23 million, but collected over 24 million for this project. They tell us and they share with us that there is a remaining balance of about 1.04 million, and that's a rounded off number for this project, and that they are requesting the custodianship to be able to utilize these funds for capital improvement projects and for their general operating expenses. We did get a fiscal note from BBMR or DOA based on the law. We do have the resolution from Gura and the supports from the chairman and the executive director. In speaking to Gura and again with Mr. Santos just this morning, asking for the letter from the Department of Administration, because that's where the original law, the program was assigned to. They just shared with us that they are in support, but they're waiting for the governor's office to send that letter down, and I haven't received it yet. So I just wanted to present that to this body. So Gura has been doing this due diligence for over 35 years, and they want to be able to have the custodianship for this program. And I ask that my body, that my colleagues in this body, please support this effort and give the custodianship to Gura.
Thank you very much. Any other senator wish to be heard on Bill 327? Any senator wish to be heard on Bill 327? Seeing none. On the motion to send the bill down to the voting file, there being no objection. Senator Addy, you're recognized on Bill 337.
Thank you, Mr. Speaker. I move that Bill 337-32, as amended by the Committee on Rules, Federal, Foreign, and Micronesian Affairs, Human and Natural Resources, and Election Reform, be placed in the third reading, and I'd like to discuss it.
Any objection? Seeing none.
Mr. Speaker, the Bill 337 seeks to basically update the current statutes that we have, which governs the regulation of underground storage tanks. Now, underground storage tanks includes the approximately 55 miles of buried pipeline that transport fuel, for example, from the Navy fuel farm all the way up to Anderson, pipelines that transport fuel from the Guam Power Authority here at Cabras all the way to Tangisan Power Plant. And in those 55 miles of buried pipeline, there's approximately a static capacity of about 3 million gallons that are stored there. There's also about 300 regulated underground storage tanks with a total capacity of 90 million gallons of fuel. Now, that's the capacity. How much is actually being stored in there, of course, is another matter, and that varies from time to time. But the whole concern here, and of course these regulated tanks are spread out up to about 136 different sites throughout the islands, gas stations, the hotel, down at the old Gorco fuel refinery. Now the concern here is we want to make sure that, of course, if there's a leak that should develop from these tanks, it could have some very serious impacts on our underground water resources. And so, an underground storage tank, just because you see the tank sitting on top of the ground, that is included because there are some portions of that are actually below ground. So the intent then of Bill 337 is to tighten up certain parts of our existing statutes regarding the regulation of these underground storage tanks. The first thing that it does is, of course, it increases the penalty for operators of these storage tanks from the current penalty of $11,000 per day per tank for each violation that has been cited, up to an amount of $16,000, and that brings it up to the level of the penalties that are currently in the books for the U.S. EPA. The other thing that it does is that the current statute basically makes a violation of not being responsible about maintaining these tanks as a misdemeanor. We found that the problem with so basically the bill will decriminalize it and will make it a civil penalty, because by making it a misdemeanor, we found in like we did with the traffic citations that the charge to be brought to the court needs to be filed by the Attorney General's office, and we all know that the Attorney General's workload, of course, if he had the choice between allocating attorney resources to a murder case versus legal resources to bring a violator who did not maintain his underground storage tanks in a responsible manner, he'll probably take the murder case. So by making it then instead a civil violation, then actually Guam EPA can take it directly to court to file for the penalty to be assessed to this violator. The third and final thing that the bill does is that it really puts in some new parameters regarding what does an owner of a storage tank do when they decided that, okay, we no longer have any use for this tank, and so we're going to abandon it. So what the bill requires is that owner cannot just put a padlock on the valve and walk away from it. He's actually going to have to go through certain closure requirements, and once he's done with that, then EPA comes in, they do an inspection, and basically then that removes the responsibility or the liability on that owner after EPA has looked at it and says, okay, we are satisfied that this tank has been properly closed down. And so, we've come across cases, EPA at least has come across cases where a construction was being undertaken, and as they were digging up the ground, they find that lo and behold, there was an abandoned storage tank down there that nobody even knew about. A good example of that was when that tri-intersection road construction was going on up in Barrigada. As they were digging the road, they found that there was this big 500-gallon underground storage tank that was, in fact, abandoned, but nobody had any records about it. And so if a situation like that should occur, then it's going to have to be mitigated. You're going to need to either take it out or fill it up with cement or whatever. And then that's where these penalties that are assessed in instances where appropriate can then be utilized to do the necessary rectification of the situation at hand. So that, Mr. Chairman, Mr. Speaker, is what Bill 337 does. This bill was worked extensively with Guam EPA. It was also circulated amongst the petroleum companies and operators out there that might actually be affected by a bill such as this, and we've gotten input from them. Most of the input, of course, has come from Mobil, who is the largest petroleum operator on the island. And so the concerns that were provided to the committee were taken into account and incorporated in the bill, and I believe that we have reached the consensus of operators who might be affected by this, Guam EPA, who was tasked with implementing the regulations and basically watching out for these particular activities so that our groundwater resources are protected. So I would ask my colleagues to support the bill so that EPA can go about its work, regulatory function in a much more effective manner. Thank you.
Thank you very much, Senator. Any senator wish to be heard? Senator Yamashita? Any senator after Senator Yamashita? You're recognized, ma'am.
Thank you very
Senator Limtiako. Okay, thank you.
Thank you very much, Mr. Speaker. Mr. Speaker, I appreciate Bill number 337-32 because it certainly is going to help everybody become better stewards of our environment, as well as holding people accountable for their work. I do have a question. I think I know the answer, but this is the question, and if the author would yield. On page 3, we start referring to a UST LUST fund, L-U-S-T fund. And I'm thinking the letter L stands for leaking, but I'm not sure. And somewhere along the lines, we can actually define what that really stands for.
Do you yield?
Yes, and I'm, I know that LUST, I think it stands for leaking underground storage tanks, and I'll have to go into the committee report but underground storage tanks is one large, area in itself, and then the LUST part of it kind of narrows that down to then the issue of leaking underground storage tanks. But I will look back into the committee report to make sure that L stands for leaking.
Thank you. And then if in here it is referred to so that it's as clear as can be when people are reading it, so that we do know that L stands for leaking. Thank you, Mr. Speaker.
Thank you. Senator Limtiako.
Thank you, Mr. Speaker. Mr. Speaker, I definitely rise in support of the intent of the legislation. Just have a couple of questions, if the author would yield. On page 2, the lines 10 and 11 cite the number of releases from underground tanks and puts that number between the years 2000 and 2013 at 139 releases. If the author would yield, just trying to get a feel for the fines, penalties, and assessments that were associated with those 139 releases, just to get an idea of the intent of the bill. Obviously, is to properly fund EPA and the administration to properly maintain these UST, or these underground storage tanks, and enforcement. And I just want to understand what that dollar value is and whether it will actually be effective in doing such, and whether it properly funds the EPA.
Do you yield, Senator?
I will yield. However, I'll admit I don't know what that amount, if there was any penalties that were assessed and collected. But what I am aware of is that there were 139 incidences, and so it does happen. I know that just, I believe, earlier this year or last year, there was a fuel spill in Tumon, and of course about 500 gallons of that. And so, you know, even up to this day, it still remains. And I think EPA, I know that EPA doesn't look at this as a source of funding for its operations, more so than an economic disincentive to the operators that, you know, you might as well, we better fix it now and change that $10 gasket. Otherwise, it could cost you $16,000 if it is found to be negligent.
Anything further, Senator?
Yeah, thank you,
Lieutenant?
Mr. Speaker. And just as a follow-up, on page 4, it does appear that in section 2, that it does appear that the money would be used in some sort of fashion, including personnel costs for operations. So, of course, my concern is not in disagreement with the intent. I support the bill fully. I just want to understand whether or not it sounds promising. I know that there's stiff penalties associated with the remediation and closure of these tanks, but I just want to get a feel for whether or not those resources can support the intent of the bill. Either way, though, Mr. Speaker, I am in full support of the bill. Thank you.
Thank you very much. Any other senator wish to be heard? Senator Muñoz-Barnes.
No, I just probably have a question just based on if this is, Mr. Speaker, if I may. I know that when the fund was created, it was under the U.S. Underground Storage Tank Management Fund, and then we're going to refer to the UST Lust Fund, the Leaking Under Storage Tank Fund. So I just want to say, are we going to underline and strike out the USTM fund and then do the UST-LUST fund? I'm just wanting to make sure that, so it doesn't get mixed up.
I think we need to take a short break so that the, we'll take a short break.
I just wanted to make sure.
Senator, you still have the floor.
C2 Ismasi, Madam Speaker. Madam Speaker, after consulting with the author and then, of course, legal counsel, I guess the referring of the leaking underground storage tank fund based on existing law is still stands okay, and that the funds, any funds coming from any violation will go into the underground storage fund. So if it's don't fix what's not broken yet. If it comes up in the future, then we'll make the amendments there. But just based on the existing statute that was already in there referred to, so I won't make any amendments. Senator Masi.
You're welcome, Senator. On the motion, is there anyone who would like to speak on the motion? Yes, but I want to give courtesy to the author, but he's out in the halls right now. Senator, do you want to close?
Yes, Madam Speaker, and I just want to close by answering the previous speaker's inquiry about what does the L stand for in the LUST, and it does stand for leaking underground storage tank. But beyond that, I ask for my colleagues to favorably consider the bill. Thank you very much.
You're welcome, Senators. On the motion then to send 337-32 to the third reading file without any objections, so ordered. Bill number 347, Mr. Vice Speaker.
Madam Speaker, I move that Bill 347-32 be moved to the third reading file and ask for an opportunity to speak. Madam Speaker, 348 is a companion bill.
Wait, so on the motion then to put
Yeah,
in the third
I
reading?
understand. I'm just wondering if I can move both of them down at the same time, or no?
No, we'll do it
Okay.
individually, sorry.
All right. All right, Bill 347.
Okay.
Madam Speaker, this is a bill to rezone lot P10.9A-3-R19 in the municipality of Dededo from agriculture to commercial. Madam Speaker, at the public hearing, the mayor of Dededo, Melissa Savar, has appeared, and she brought with her a copy of a municipal planning council resolution that supported the zone change. In fact, they supported the zone change, and DPW had granted a variance, and there is a small convenience store on the lot. The Municipal Planning Council also noted that the concerns of GPA and DPW were addressed, and that the Route 1, Marine Corps Drive, is large enough to satisfy all the needs of parking and the other needs of the area. And so the Municipal Planning Council and the mayor support the rezoning from A to C on this one. And Mr. Michael Borja, Department of Land Management, was at the hearing, and he voiced no objection. Though he would have preferred that it went through the process, he voiced no objection, inasmuch as the Municipal Planning Council was supportive of it and noted that his department had previously granted a variance for the commercial use. And so he did not want to stand in the way of families enhancing their income by leasing the land out for commercial purpose. So I ask for my colleagues' support in this zone change. The map is attached to the committee report and the Municipal Planning Council resolution. Thank you, Madam Speaker.
On the motion, Senator Limtiaco.
Thank you, Madam Speaker. And Madam Speaker, just as a rule of thumb, on all of these rezoning bills that come through this legislature, I just feel it's my obligation to just ask the question again. Why does this have to come through this body? Why can't it just go through the normal course of action? Obviously, there's a Department of Land Management has the capacity and the expertise to properly vet these bills. Yet we have a bill that comes in on a half a page, and I'm not questioning the merit. I want businesses to succeed. I want them to have the opportunity to gain from their property in the best way possible. But once again, we're seeing a circumvention of a process that exists to properly vet these, and yet we still shove these through the legislature time and time again without the proper expertise to analyze the impact. And yes, you can have the public hearings, and if people show up, great, and if they voice their concerns or not, great. But once again, there's a process for it. Why can't we just follow that process? Why does this body constantly have to circumvent the laws they put in place to do that? I just don't understand it. And although I probably don't have the support of my colleagues, I would just ask that please let it go through the process. If there's issues with the process, let's fix it. But let's stop putting these bills through the legislature. It's not the right place for it. Thank you, Madam Speaker.
You're welcome, Senator. And I know you asked the question. I've asked the question myself. If anybody here feels, they can answer it, please do, because I don't have the answer as well. Does anybody would like to attempt to answer why you introduced these bills and put them through? Well, I guess not. So anyone else
Speaker,
who'd like to
wait,
speak
Madam
on the
Speaker.
motion?
Wait, Madam Speaker, if I may.
So you're going to answer the question?
Well, I'm not, whether it's an answer or a statement or a comment coming from a senator voted by the people of Guam, when the legislature was first created, there were duties and responsibilities that were afforded our way. And based on what this august body creates and passes and creates it by legislation, there is a process of how things were done. So based on how the Guam Legislature was created, there were a couple of things that were afforded our way, not just being given a button and a pin when we get inaugurated as a public servant to the people of Guam. And I don't know whether I'm going to stand with a point of personal privilege, but at least when this body was created, they gave us some authorization to do a process. And yes, there may be an administrative process to go through, but it's a one point or another. And whether the question keeps getting asked again, I don't have any problem saying that the people voted us in, and it is our duty and responsibility to hear the concerns of our people. And if there are routes or regulations to take to move an issue forward within the community, you can do it through the legislative process. If there are laws that provide that it does through the administrative side and says, or you can do it through that. But don't take away the privilege that's been given to us. We don't have much to begin with. And if the people do not like what we're doing, now, Mr. Speaker, that you're on the podium, then they can change us every 2 years. And let me tell you, there are a lot of laws in place that enable this august body to do things. The same way that we have AAA processes within the administrative body before it comes back here. So based on my understanding, and I don't have a Juris Doctorate and I don't have a master's, but I will tell you that at least the people of Guam have given me that authority to look and listen to constituent concerns and creative ideas to come through this body. And that provision to do this process was afforded our way. And this august body made some changes. If a land was not officially zoned, then it was the responsibility of this body to make that change, to make it zoned to where it was supposed to go based on existing surroundings. So you know what, Mr. Speaker? I don't know. Maybe I'm going to lose for this, but I'm not going to take away the privilege that was given to me as a policymaker to listen to my constituents, to be able to go through a process. And in the past, the reason why some of those legislations came our way was because there wasn't a quorum. So there is checks and balances. Si Diyos masi.
Thank you. Madam Speaker, you're recognized.
Thank you very much, Mr. Speaker, and for covering for me up there so that I can speak to the matter of the question, of course, asked by one of our colleagues. And, you know, it's the exact same question I've asked since day one, since I've been here. And I've asked this question because I know that this legislature, not this, but the legislature, passed legislation and created a process to actually go through a department to be able then to have them vet, you know, the more important is to protect, I suppose, really our environment. No, not suppose it, they really are. And the reason why I say that is because a GWA would have to respond to make sure, first of all, is that the access to water is available. EPA is involved because they want to make sure that, especially in certain parts of our island, and we have laws that where there are no access to even sewage, that now we require that lots be of a half-acre size, so that then there could be a septic tank and a leaching field, primarily so that it will not then filter into our drinking water. So EPA wants to make sure that that, you know, is protected. DPW want to make sure that there are roads, of course, and runoffs, also to make sure that, again, there will not be contaminants running into our drainage system, that then we end up burdening, again, the government more now, because if there are no infrastructure there, then everybody's going to look to the legislature and the government to say, because, you know, I got this zoning now, it's your responsibility to make sure that it is accessible. Fire is very critical. They have to respond to make sure that there's adequate space for egress and degress. GPA is also critical to make sure that the utilities, power lines will be able to go in there. There's a whole gamut of government agencies whose sole purpose is to protect, of course, the island, the people, consumers, everyone in essence. Why then, in essence, that it goes through the legislature? For simple reasons, I guess, because yes, people come to the legislature, they approach certain senators and ask them to do this because it's a quicker process and because it's cheaper. And I say this primarily because I've been through the process. I've actually had my piece of property rezoned, and I went to the Department of Labor. I went through the process. I saw all of these departments and agencies, and I responded to their concerns, and I made sure that all of those concerns were addressed in my building, in the parking facility, everything. And yes, it took a while because, and you know, and some of my colleagues, my former colleagues, they're not here now, but have actually come to me and said, why don't you just ask me and I'll rezone it for you? Well, I didn't, because I know there's a process. And granted, although this legislature can do it, I mean, you know, seriously, our primary job in this legislature is to pass a budget. Now, because yes, there are some properties that have not been zoned, and land management will take the position that it's only the legislature who can then give it a zone designation. So if a land is returned from the military, it has no zoning, we then must give it a designation of a zone. And I remember this discussion came up, and we said, you know, we should just make all lands that automatically gets returned to the government be agricultural at the lowest level possible, and then the individuals, private owners, can take it then to the level in which they would like to have it zoned so they can take full advantage, yes, of their property. And I'm not denying that they shouldn't be. They should be. But why in the world do we create a process, and then just because we're legislators and we're so powerful in the sense that once we pass a law, that's it. But of course, you can't tie the hands of future legislatures as well either. So, you know, I understand where my colleague is coming from, and I always take this position. I always say that when we do this, to rezone, that the least I could see would be a map And sometimes there's not even a clear map. And the other thing also that I look at in even the reports is, have the individual, oh wait, let me go back a little bit. I remember one person came to me to rezone, because I guess people tell others, don't go to the speaker because she doesn't normally support this. But one person did come, and I'll tell you what I did. I said to this individual, you personally go to GWA, you go to GPA, you go to the fire department, you go to DPW, you go to all those agencies that are required by law, and you yourself, if you want to speed up the process, do this, get clearances from them, and I'll provide all the data then in that bill, so to be able then to have then this bill go through. Because if I'm going to ask this of everybody, I have to ask this of myself as well if I'm going to introduce a bill like this. So, however one wants to take this, that's, of course, their prerogative. My concern here is when I do this, I want to make sure I protect the entire citizens of the island, that, we're not going to create a bigger problem in the long run when departments and agencies who have that regulatory responsibility to make sure that, everyone is in compliance, that, it is followed. So that's my response to Senator Limtiaco.
Senator Nicholas.
Thank you, Mr. Chair. Just to put this out there, there's merits to both sides of the equation. To follow the regulatory process is, of course, the best course of action. The reason why the legislature does have the authority to be able to rezone within the body is to provide a check and balance against the potentialities of an administration purposely holding up a rezoning of a property for any reason. And in my opinion, that should be the only time really where we step in and do it legislatively, when the evidence suggests or clearly demonstrates that there is an unnecessary administrative hurdle being placed upon people. Then it would be prudent for a check and balance and the legislator to step in and ensure that people are being treated fairly. So I would just like to proffer that the authority for the legislature should not be taken away for us to be able to rezone in order for us to maintain that check and balance. However, we should also maintain the discipline of as much as possible ensuring that the proper channels are being followed through with, so that all of the checklists are good to go and nobody's going to be adversely affected by these zone changes. So I can see how both sides of the issue have merit, and the reality is that both sides of the issue will always have merit. And it's really up to us to determine when a situation merits our bringing it forward in this body versus us referring it back to the proper channels. And for me, the only time that I would entertain a zoning change, and I haven't done one, and I don't think I will, is only if I can see evidence that suggests that there is an unfair administrative hurdle being placed on somebody, and we need to remedy that in order to be fair to that person. But that being said, I do appreciate the dialogue. I think that this is healthy for us to constantly come back and recheck ourselves and really ask the questions as to why we do the work that we do. And it's good for our people to hear that as well. Thank you, Mr. Speaker.
Thank you very much. I'll take a short recess.
Mr. Vice Speaker, you recognize? Okay, so he would like for us to send Bill 347-32 to the third reading file. No objections, so ordered. Bill 348, your companion bill.
Madam Speaker, I'd like to place 348 on the third reading file and ask for an opportunity to make a short statement.
You may proceed.
Madam Speaker, Bill 348 is the companion bill to 347. There are adjoining lots, but under the rules, they have to be separate bills. They both front Marine Corps Drive. There's adequate roadway and facilities for all the infrastructure. The Municipal Planning Council of Dededo has voted on a resolution in support of the zoning change. And with that, I'd like to ask for the support of the colleagues.
On the motion, Senator Limpiaco.
Madam Speaker, once again, just as a matter of course, these properties front Marine Drive, and I believe that the Land Use Commission has already designated all of these properties that front these main routes are can automatically be zoned in one of these areas, such as commercial or some industrial use. So that's even more to the point of why some of these bills would be expedited through the Land Use Commission, and if we just followed the process. You know, there was some comments made on the last bill that suggests that because the senators have the power to do so, that they should just do so. But that's not what the Land Use Commission was put in place to do. And I commend you, Madam Speaker, on the words that you had to say, because it was entirely accurate. Let it go through the vetting process so that we can make sure that we don't miss something. And for these two particular processes, the Land Use Commission has already designated these main route fronted properties as eligible for it. So it would have had no problem going through the process. And so once again, I just don't understand why we circumvent it. We should let it go through the process. And Senator San Nicolas also made good comments that yes, in the event that it gets tied up, then sure, bring it through the body and let's figure out why it's getting tied up. But for those that, to even for any senator to entertain these bills without asking or begging the question or seeing if it's gone through the process, does a disservice to our constituents. Thank you, Madam Speaker.
You're welcome, Senator. On the motions, anybody else would like to speak? There being none, on the motion then to send 348 to the third reading file without any objection, so ordered. Bill number 349, Senator Frank Uggan, you're recognized.
Talk about timing in regards to legislation. Madam Speaker, I'd like to please move for the support of our colleagues in the placement of Bill number 349-32 COR. Although this particular situation, perhaps from a perspective of going through the process, may have a different angle, I just would like to comment on it and move for the placement as a third reading file, Madam Speaker.
Okay, you may proceed.
Thank you very much again, and to the good chairman of the committee with the land oversight, I want to thank him for having the public hearing on this particular legislation. Madam Speaker, this is a situation where children of a deceased family or parents, two deceased parents, apparently inherited the property. And what had transpired is that the building was expanded and was discovered after they had inherited the building and the property that in fact it was not properly zoned. They came to my office, the Mercado family came to my office and requested that in fact their property be rezoned to the appropriate zone so that they can correct the situation. And I want to thank the chairman because even the director of land management came forward and requested that this process go through the chain. We respected that. I asked Mr. Mercado if by any chance he could work with the director of land management, and over the course of 2 weeks, if in fact there's not some reasonable discussion and progress, to please come back to my office and they will discuss what appropriate course of action would be taken. Well, Madam Speaker, after about 3.5, 4 weeks, he finally came back to my office and he asked if by any chance we could consider the legislation and push it through this legislative process. My office had communicated with Land Management, the director, asked him for any comments that he would like to provide, and he consented to go ahead and proceed with entertaining it on the floor. So, Madam Speaker, looking at the process and understanding that even the director has recognized for whatever reason that the agency was not able to address it within the timeline that was suggested, he responded in an affirmative manner and said and encouraged us to go ahead. Or he consented. I don't want to say encouraged, but he agreed that perhaps going this route would be a lot quicker. So that's where we're at today, Madam Speaker, is looking at Bill number 349, which is an act to rezone lot number 5221-1-4-R1, located in the municipality of Barrigada from agricultural zone to multifamily dwelling zone, R2. And that's to allow and to, first of all, to recognize the structure that is in place in that property. This recognizes that, in fact, it's not in conformance with the zoning code, and it also would rectify that by virtue of assisting the family. So, Madam Speaker, I ask our colleagues, in light of the communication and the openness that we try to share with the Department of Land Management and the family members, I'd like to ask our colleagues for their consideration and their support for this rezoning measure. Thank you very much, Madam Speaker.
You're welcome. On the motion, Mr.
Madam
Senator
Speaker,
Limtiaco.
sorry for taking up all the airtime today regarding these bills, but this is exactly why the process is so important. Because when things like this happen, unfortunate families like the Mercado family are stuck with issues that they have to address after the fact. The reason why it probably took forever to get through the Land Use Commission is they were probably wondering, how are they going to correct this? Obviously, the permits, the building permits that were used to construct this property were not obtained. Somehow, some way, you had what appears to be a single-family residence turned into a multifamily residence illegally, and at no fault to the errors of the estate. But this is exactly what the process is intended to properly vet. And instead, we have someone that circumvented the permitting process, built the property, and is coming back after the fact. What is the effect of the utilities? What is the effect of the sewer and the water? Is it septic tank or not? Is it on the sewer grid? We have a multifamily. Earlier in this legislature, a bill was brought forward with a multifamily dwelling that was still on septic tank. We just finished hearing a bill regarding underground storage tanks and leaking storage tanks, oil, yet this is the same sort of harmful incident where you could have sewage leaking into the water lens. So once again, I'm just trying to allow this body to understand the importance of letting it vet properly through the Land Use Commission, and once again expand on the words that you had said. It's for the betterment of our municipal planning, to make sure that the right zones are put in the right place so that you're not mixing industrial with residential. Look at Harmon, for example. If anybody's driven through Harmon Industrial Park, Lord knows that was not what was planned, or should have never been planned like that, because it just doesn't make any sense. So, Madam Speaker, I just want to thank you for the opportunity to speak.
You're welcome, Senator. On the motions, anybody else who would like to speak? There being none, Senator Agun to close.
Thank you very much, Madam Speaker. Madam Speaker, with all due respect to our colleague that just the preceding speaker, I take exception to the comments that are made, only because the chairman had yielded during the course of the public hearing on this particular measure and encouraged the Mercado family, likewise myself, to work with the appropriate government entities. Then, after 4 weeks later, we receive information that says, okay, if you want to proceed with your legislative measure, then by all means, from the authority representative. And that's why I take exception to it, because he's absolutely right. We create a process by this body. In most cases, people should go through that process. But in this case, as was alluded to a little earlier, we went through indirectly by encouraging the family members to work with land management, and the director comes back and, like I said, not consented but yielded, or not yielded to going through with this measure and entertaining it in this body. So with that in mind, I share certainly my concern about that, but if in fact the appropriate authority yielded to proceeding with this legislation, then I don't know what the issue is. But he's absolutely right also. There's a process in place. We yielded to that, the chairman yielded to that. After a short period of time, insufficient progress was being realized, so we decided to place this on the agenda. So I thank you, Madam Speaker, and I certainly ask our colleagues, inclusive of our good previous speaker, to consider supporting this, considering the facts. Thank you very much.
You're welcome, Senator. So on the motion then to send 349 to the third reading file without any objection, so ordered. 352, Senator Tom Adda.
Thank you, Madam Speaker. Madam Speaker, I move that Bill 352-32, as amended by the author and the committee, be moved to the third reading file, and I'd like to discuss it.
You may proceed.
Madam Speaker, the intent of Bill 352 is really to expand the pool of potential candidates that the governor can select from for to fill the position of fire chief or police chief. Now, these two particular positions by law have very specific requirements. You've got to have so many years of experience as, for example, a firefighter. You've got to have so many years at senior levels, and the same thing for the police. So the qualifications are such that really the candidates for these positions, for the chief, have to be either coming from GPD or maybe coming from another police department that would have actually met these qualifications. So take, for example, the case of the Guam Fire Department. At the beginning of this administration, I believe there was 2 candidates that were submitted. 2 of them really did not pass muster. And finally, you know, it got to the point that the department was really kind of like, okay, we need to put a leader in place. So somebody, the current fire chief, stepped up to the plate, and he says, okay, if you want to nominate me, I'll take that position, and if I pass muster with the legislature, I'll go in there and I'll serve to the best of my abilities. Now, this particular individual, who really is a fire specialist, that's Chief Joyce Nicholas, met the qualifications, met the timing grade, the educational requirements and all that, and the legislature confirmed him. Now, in doing that, though, he had to make some sacrifices. Basically, right now, he's probably earning less than, because the salary level that's been established for a fire chief and a police chief stands at $87,000 a year. The current fire chief was making certainly much more than that. And over these past, so far, I believe over the past 3.5 years, he has lost something like about $70,000 in income by having stepped forward to make this sacrifice. And so we made some survey, and just in the fire department, for example, within the department, active personnel, there are 3 right off the bat who clearly, without even looking any further, will meet the qualification requirements established by law to fill that position. There's another additional 22 that could possibly meet the qualifications. They would just need to be further evaluated. Now, these are just individuals who would be eligible to be considered to be appointed by the governor. So then what we have is now under the current statute, the governor basically has a field of maybe 2 or 3 retired fire personnel to pick from, versus possibly a field of 25. And the same thing exists in the Guam Fire Department. You got police lieutenants who are making way, way more than what the police chief is making. These guys aren't going to step up. I mean, it takes an exceptional individual, somebody who's seriously wants to, get the ship in sailing properly, in the proper direction, and to step up and make that sacrifice. And so, because of that, you find also for the Guam Police Department, again, the governor is pretty much limited to appointing people who have retired and are willing to go back up and serve, be a public servant once again. And that field is pretty limited. You can count it in one hand. Whereas if you take a look from within the department, you'll find that you can quadruple really that potential, the field of potential prospects that the governor could pick from. And I believe that by doing that, we can then, the community can be better served because then, the finest can be appointed. Now, the way then Bill 352 proposes to address this particular issue by incentivizing the personnel within the Guam Fire Department or within the Guam Police Department to step up and say, I'm willing to serve in the position of fire chief or police chief, if you so want to nominate me and I can pass muster at the legislature. So Bill 352 proposes to do that by then revamping the compensation arrangement for these two positions, the police chief and the fire chief. And then for somebody then who gets nominated, such as, for example, the current fire chief, if he gets nominated to the position of fire chief, in order to avoid him losing any income, the bill proposes to take the average of the three most recent annual salaries. So, if he was earning $120,000 average for the last 3 years, then basically the salary of the fire chief will be set at $120,000. As opposed to $87,000. Now, of course, if somebody is nominated by the governor to serve in that position and is already a retiree, then that retiree will come in and serve as a fire chief at the pay level of $87,000, which has been established by the Department of Administration. So I believe that provision then, insofar as changing the salary, the compensation that will be allowed for the fire chief, would be set at whatever the average salary is for the last 3 years prior to being nominated. And what that average would then incorporate would be all the overtime that normally would have been earned during that period there. And that's why their salaries are really pretty high for the fire and for the police chief. Now, the other aspect of the revamping that Bill 352 does is that the current law right now, if, for example, the current fire chief or the police chief, they were on active duty with the department, and they stepped up and they said, nominate me, I'm willing to serve, and they were. Now, if after this term, they, a change of administration, there's really no guarantee that they're going to be able to return back to a position to finish their service for purposes of retirement. So that, again, becomes a significant disincentive. So, I know that one of the chiefs, I believe he's got all the years that he needs to retire, and, he could retire today. The other guy still has probably another 10 years, but he took that risk, okay? And he wanted to be a public servant. So now what Bill 352 is saying that then, if then his term is completed and he wasn't thrown out of the job, he can then return back to the position that he previously held or a position equivalent to that. So if he was a fire lieutenant, he can return back to a fire lieutenant position or an equivalent of a fire lieutenant. And finally, and so that actually then are the two major changes that the Bill 352 does. It establishes a new compensation scheme, and it makes provisions for that chief to return back to continue his active service so that he can work towards full retirement. Now, I will point out two things that were brought to my attention, which I did not include in the bill simply as a matter of my own personal philosophy. Now, somebody brought up the question of, okay, fine, so I'm not going to lose any income by taking the position of fire chief. And so that's fine. But, really the question was asked, why would I want to step up? I'm earning $110,000 and responsible for this part of the fire department activity. Now you want me to step up, and I'm going to agree to step up to take the whole fire department under my wings to continue earning the same amount of money. And so the suggestion was made, maybe you can further sweeten that by giving a 10% incentive, at least. So, okay, you're going to step up, you're going to take on more responsibilities, and you're going to get, additional compensation for that. I did not put that. I think it has merit, and if anybody wants to make that amendment on the floor to include that provision, I certainly would not object to it. But I did not include it in there simply as a matter of personal philosophy that I believe that an individual, if he's going to step up to that position of leadership, it's because of that self-satisfaction. You're going to have reached that, in the Maslow's hierarchy of needs, finally the self-actualization to be able to go in there and apply everything that you've learned, all the experiences that you've had to run that organization the way you think it should be ran. And that's where the big satisfaction is. And the 10% differential in compensation, for me at least, would be of no consequence. It's the satisfaction that you get from going in there, leaving your mark that you've done, and that you've left that organization better than the way it is. So that's certainly one consideration that if anybody on the floor wants to make an amendment, I will not object to it. I would, and I'll leave it at that. The other item is that I think for a person to step up to provide his public service, and again, I think the current fire chief has done an excellent job. But he would have lost about $70,000 in income. He's a young man. He's got a young family. That's a lot of money to lose. And I think it'd be appropriate to put a provision in there to actually put a provision that would allow for a retroactive pay. So if this bill is passed and now his salary is back up to, let's say, $110,000, would have been the average, is that the difference between the $87,000 that is set by Department of Administration and the $110,000, again, the math, never mind the math, but there's a loss in pay, is that he be made whole, and to make that retroactive back to January, and that I think is a consideration that certainly is worthwhile considering if any of my colleagues want to entertain that. So with that, Madam Speaker, Bill 352 as introduced, as amended by the author and the committee, I think will go a long ways in expanding the pool of choices for the governor to run these two very important public safety organizations. And I would ask my colleagues to favorably consider the bill. Thank you.
On the motion? There being none, on the motion then to send 352 to the third reading file without any objections, so ordered. Bill number 354, Senator Nicholas, you're recognized.
Thank you, Madam Speaker. I'd like to make a motion to place Bill 354 in the third reading file.
Is that the original bill? No substitution or anything?
No substitutions, Madam Speaker.
You may proceed, Senator.
Thank you, Madam Speaker. Bill 354 is a bill that just amends the sign laws. It was brought up by former Senator Klitsky back in March of this year, that there is existing law in the books that does make the posting of any kind of political signage in violation in violation of the sign zoning laws if they are beyond a certain size. And we are well into election season. There are many signs that are on private property. And so what this bill intends to do is to protect the ability of individuals to freely express their political affiliations and their political positions. And so this bill would allow for private property owners to be free to display political signage as it relates to candidates or any other matters to be considered by the electorate, provided that such signs are posted on property adjacent to any roadway 8 feet from the roadway and do not block or impede traffic or any driver's visibility. So this is just really a housekeeping issue, Madam Speaker. We already have word from the Department of Public Works that they are not enforcing this violation that's on the books because of the free speech underlying issue. So just for the sake of housekeeping and with respect to Senator Klitsky, who did properly point this out, I would like for our colleagues to please support this so that we can put this matter to rest with respect to the freedom of speech of our people. Thank you, Madam Speaker.
You're welcome. You're welcome, Senator. On the motion, Senator Limtiaco, you're recognized.
Thank you, Madam Speaker. Madam Speaker, we've done some research, and this sign issue is definitely something that needs to be addressed, not just for political signs, but for the sign laws in general for Guam, because most of the signs out there are already in violation per the sign law. Yeah, and granted, the sign laws are probably somewhat antiquated and need to be addressed holistically. However, I rise not in support of this bill, and I believe, and I can't speak for Senator Klitsky, but I think Senator Klitsky's intent was to prevent or to somehow enforce the existing sign laws so that political signs are not on private property, not to otherwise allow for signs on private property. And I understand it's political season right now, and I've had the good fortune of not having to put up signs this year. But nonetheless, I think we're already inundated with the signs. There's enough easement property to go around, and with Senator Yamashita's prior law to actually limit the size of those signs, I think that was a step in the right direction. I think this bill would be going in the opposite direction of not only increasing the signs, and I know that the intent of the bill is to not make these private property owners in somewhat violation of the law, but I don't think that was that is the intent necessarily, to increase the amount of signs that would otherwise go up at political season. And really, we should be going the other way. We should be reducing the locations that these signs can be put up. We should be decreasing the size of the signs, obviously. And so to go from not only private property, but to the if I read it correctly, I think there's also mention of not only agricultural zones, but commercial zones and industrial zones as well. Lord knows we don't need any more signs, especially during political season. And so, Madam Speaker, those are my concerns, and I stand in opposition to the bill. Thank you.
You're welcome, Senator. On the motions, anybody else who would like to speak? Would you like to close? Senator Nicholas?
Thank you, Madam Speaker. We are very much inundated with signs. We have so many on the roads, and you know, there's mixed opinions about how people feel about them. For me, the overarching issue isn't so much what season we're in, but what our people and what their rights should be. And with respect to private property, whether it's residentially owned, commercially zoned, or industrially zoned, you know, our people should be able to have the right to make whatever political statements they want to make. I mean, that's fundamental to the freedoms of this country. And to have a law on the books that seeks to suppress people's ability to express themselves, especially politically, I think is very contrary to what so many people have died for. You know, if we're trying to say that you can't put up a sign saying how you feel about something unless it's a certain size or unless it meets certain specifications, we need to be very, very careful about how we're trying to stifle the ability for our people to freely express how they feel about political issues. And that's so important because not only does it relate to elections and votes, but it relates to actual issues. I mean, I am a history major. I was a history major at the University of Guam. I wasn't born at the time, but during the Vietnam War, we saw huge expressions of our people with respect to the involvement of the United States in that conflict. And throughout history, we have seen major expressions of our people with respect to political issues that they take to heart. And anytime a government tries to suppress the ability of a people to express as loudly and as vibrantly as they desire their position on any political issue, that for me is the biggest step backwards that we can possibly take. If we need to limit political signs, perhaps the limitation should actually be on the easements. Maybe we shouldn't have political signs on easements. Maybe it should only be on private property. I mean, that could make sense to me. But to limit private property owners and allow for easements, that's, I think, a misapplication of where we actually should be allowing the freedom of expression to extend itself. So I see where the retiring speaker is coming from. There are a lot of signs on the road. I'm sure we might be seeing more, but I think that if we're going to be trying to limit the number of signs, we need to limit its placement on public areas, but we should never, ever limit the ability of our people to politically express themselves or to politically make opinions or statements with respect to where they stand on any issue, because that is fundamental to the empowerment of our people to always keep their government in check. So I thank the body for allowing me to introduce this bill, and I ask for their favorable consideration. Thank you, Madam Speaker.
You're welcome, Senator. So on the motion to send 362 to the third reading file, no objections, so ordered. Bill number 384, Mr. Vice Speaker, you're recognized.
Point of order, Madam Speaker. That was Bill 354 that we're moving to the third reading file.
Okay, I'm so sorry. Yeah, so
Bill 362
for
is...
record, you're right. I had scratched it out already. It was 354-32, the third reading file then, without any objection. So then now the next bill would be 362, Senator Nicholas.
Thank you, Madam Speaker. Bill 362 seeks to, I'd like to make a motion to place Bill 362 on the third reading file and have an opportunity to discuss the bill.
Yes, Senator, you may proceed.
Thank you, Madam Speaker. Madam Speaker, Bill 62 seeks to address multiple areas throughout the laws concerning our property taxes in order to create an environment of fairness and to provide some opportunities to our people that they weren't able to avail of due to their lack of awareness. Right now, we have the revaluations going on in our government. Properties are being revalued, which is going to result in a tax assessment based on a higher valuation, probably, if the valuations did in fact go up. What that will mean is that by next year, people will be paying a higher amount of property taxes because the values of their properties are likely to have increased. Now, there are many exemptions throughout the code that allow people to lock in the rate that they pay on their property taxes if they are able to apply for that exemption. Unfortunately, the application deadline for that exemption has expired in March of this year, but it wasn't until May of this year when Reverend Tax sent out a notice to the people informing them that the revaluations are taking place and that the exemptions are available. Anybody who got that notice in May who did not apply back in March has already missed the deadline, and they'll be locked into the new rate based on the new revaluations that are completed that are currently ongoing. So the first thing that this bill seeks to do is to extend the exemption authorization timeline for those individuals who can avail of it for real property taxes. And those individuals who are able to are our senior citizens, individuals with disabilities, our farmers, and those who are claiming their primary residence as their home exemption. So, I mean, this is a lot of people, Madam Speaker, in our community who are able to claim this exemption and lock in their current property tax rate without having to pay the higher property tax rate come next calendar year when the rates are going to be assessed at a higher value. And so what we're seeking to do in the bill is to extend the deadline to December 31st of this year, and to require that the Department of Revenue and Taxation publish in the newspaper and post at the mayor's offices a notice that the deadline to file for these exemptions has been pushed back to December 31st. In so doing, we will afford all these individuals, homeowners, senior citizens, people with disabilities, and farmers the opportunity to claim this exemption so that they don't have to pay the higher property tax rate that will be assessed next calendar year. Again, this is only being done for the purpose of making sure that our people are afforded the proper opportunity and that they are given the proper notice. I don't want to have people paying more and to find out after the fact that they could have claimed this exemption when they were never notified about it. And so that's the primary intention of the bill. Another section that the bill seeks to remedy is an area of concern that was expressed by Reverend Tax that does have a lot of merit, and that is that we don't have any identifying factors between our property taxpayers and our income taxpayers. In other words, if I'm an income taxpayer, I work and I also have property tax, there's nothing that's linking me to my property. And where that becomes a problem is when we have people who owe property tax and are also getting a refund. There have been instances where people will get a refund and then so many months later get a property tax bill. And then the question becomes, well, why didn't you just deduct my property tax bill from my refund? And the response from Reverend Tax is, we don't know how to tag your particular taxpayer identification number to your property tax. And so what we seek to do also in the bill is to require that everybody who is a property owner and paying property taxes also submits, along with their property tax payment, their taxpayer identification number, so that these two things can be reconciled, property taxes and the payment of that, refunds and the issuance of that, so that we can make sure that our property taxes are getting paid and getting offset to refunds before refunds are getting issued out. This is a benefit not only to the government of Guam, but also to the department, as it will streamline their ability to collect on the property tax side, but it's also a benefit to the taxpayer, because if a taxpayer receives a refund and they go out and then they enjoy the return of their money that was given to them only to find out that they had a bill that they never paid, it does create an environment that, that would be inconvenient for the taxpayer. So we're trying to increase the efficiencies of the department by tagging the taxpayer identification number to the actual property that's owned by that respective taxpayer. The third item that the bill seeks to address is the statute of limitations on the payment of property taxes. Now, this issue is also very sensitive, Madam Speaker, to our taxpayers, our property taxpayers. Every single tax that we have on the books, whether it's mirroring the federal government or it's local like GRT or the, actually it is just, alcohol and tobacco taxes. Every single tax that we have on the books has a 10-year statute of limitations, which means the government has 10 years to pursue and collect from you what you owe in your property taxes. But if the government fails to do that effectively, if they fail to file a claim in the courts and seek remedy through that avenue, then you are no longer held to that statute of limitation. You're no longer held to that property tax bill. And the reason why we have statutes of limitation is to protect people from having to get called out and repay something that they may no longer have the information on. And so for our property taxes, Madam Speaker, right now, we have a 30-year statute of limitations, which means if you didn't pay your property taxes 28 years ago, the government can come back and say, oh, you have to prove you owe property taxes 28 years ago. Where's your receipt? And that's very problematic, Madam Speaker, because I don't think anybody holds receipts for 28 years. I don't think the receipts themselves would be legible after 28 years. Maybe the paper itself would have even started to crumble away after 28 years. But we still would potentially require our people to prove that they owe going back that far if the books don't reconcile. And the reason why this is a big issue, Madam Speaker, is because I know a lot of our senior citizens who have communicated to me saying, boy, you know, I got a property tax bill going back to 1985. I don't have the receipt for that, you know? And of course, what do you say to that? I mean, how can you logically expect somebody to produce a receipt from 1985? I can't. You know, I don't think anybody should be expected to do that. If the government doesn't do its job in collecting the taxes within 10-year statute of limitations, it shouldn't put an undue burden on the people to produce something that is very unreasonable for them to produce. On top of that, Madam Speaker, you know, the saddest part of it is that oftentimes these are our senior citizens. And for a senior citizen to have to go through the stress of having to search for a receipt that who knows where it is, or if it's even legible, or if it even still exists, and then to have to go back and pay when it's very possible that the government itself might have made the mistake in not properly recording that they paid their property tax. A lot of these senior citizens, Madam Speaker, they don't want to have to go and bang on a table and fight for what they believe is their right. They don't want to have to go there and say, I paid that tax back in 1985. You know, oftentimes they just go there and they pay it. And that's the biggest tragedy. Because if our government is failing to keep proper records and they're erroneously billing people for property taxes going back 20 or 30 years, and our people are just going there and they're just paying it because they don't want to be confrontational, we're taking money from our people that we really shouldn't be. So it's for a lot of those kind of reasons, Madam Speaker, that we have statutes of limitations in place. The federal government believes that a 10-year statute of limitations is reasonable. We have a 10-year statute of limitations in our gross receipts tax that we just passed earlier in this term. And now the final loop that we need to close is to lower the statute of limitations on property taxes from 30 years, which is just outrageous, down to 10 years, which will align it with all of our other tax statute of limitations. The other two sections here, Madam Speaker, that have been added to the bill that's been as reported out of committee is extending the administrative timeline for the Department of Revenue Tax to reconcile the property tax roll. This coincides with the extending of the deadline. Revenue Tax submitted testimony to us saying if you're going to extend the deadline, which they do support, they do also need to have, for just this one property tax year, an adjustment of the deadlines for how they go about reconciling the roll and issuing out the billings and thereafter. And lastly, and this is with respect to the concerns that were brought up in some hearings about the seizure of property and the auctioning of property and the fact that there are no existing rules and regulations on the books on how they go about doing the auctioning. It was brought up in a hearing by Revenue Tax. They're working with the AG's office on the policies and procedures. We belabored the point that those should be adopted in accordance with the Administrative Adjudication Act. So in Section 9 here, we do, for the purposes of restating what should already be a practice, but just making sure that it's enacted, we require that any rules and regulations promulgated by the department governing the process of the sale of tax-sold property by operation of law shall be promulgated pursuant to the Administrative Adjudication Law. This will just ensure that our people are going to be afforded the opportunity to be informed and to participate in the adoption of any kind of rules and regulations that have to do with the selling of any kind of property that's seized. So I thank the body for the opportunity to present on this. I know it's pretty extensive, and we have a lot of sharp people on this body, so I welcome any kind of contributions to improve the intent of this legislation. Thank you, Madam Speaker.
You're welcome, Senator. On the motion, Senator Ada, you're asking a question, so do you want to ask your question?
Madam Speaker, I certainly, I commend the sponsor of the bill for all the work that he's put in. And I think a lot of the points that he raises certainly are very, very valid. However, in looking at this, though, the bill does not give an effective date as to when all these things. So maybe if the author can yield as to when the bill becomes effective.
Senator, do you yield to the question?
Sure, Madam Speaker. I would assume that it'll be effective upon enactment, but if we should require that language, I'll be more than happy to welcome the amendment.
So legal counsel says that it's automatic once it's signed into law. Okay, Senator Limtiaco, you're recognized.
Thank you, Madam Speaker. And just from if we can get a ruling on the standing rules side, because if I understand it correctly, bills need to be regulated to a single subject, and if reading through the bill, as the author had alluded to, there is a lot to digest. There's a lot of different issues, and I count 3 separate subject matters: postponement of the revaluation, the inclusion of a taxpayer ID, and past billing. Those are 3 subjects. It's almost as though these potentially need to be 3 bills in accordance with the standing rules of the single subject. Additionally, my issue is we just passed a budget that was predicated on these not somewhat, but partially predicated on these assessment of real estate taxes, and the postponement of the revaluation has me concerned that how will this affect the budget? How will this affect real estate taxes? What if any fiscal impact would it have? So, if the author would yield to whether or not any of those issues were raised during the committee report, or that can be further extrapolated in this discussion, so we can get an idea of whether or not this is going to affect the budget that we just passed. We talked a lot during that budget process about the education fund and the territorial education fund, and how the real estate taxes impact that. So, those are some of my concerns. But if we can get a ruling on the single subject portion for the standing rules.
I'm going to ask the author first to yield on the other question while I get a ruling on the single subject matter. So, Senator, do you yield to the question?
Yes, Madam Speaker. This all encompasses the single subject of property taxes. And as for the question of the effect on the budget, the question is coming from the perspective that the budget was passed with the intention of our people not claiming an exemption that was entitled to them, and perhaps hoping that they didn't even know any better. And the reality is that a lot of people may not have known any better. They may not have known that they could claim this exemption. First of all, they may not have known that claiming this exemption will prevent them from having to pay an increased rate of property taxes upon the point of revaluation. But what our government should have done was estimate the property taxes based on the claiming of these exemptions. We shouldn't have estimated our property tax rates for the budget based on what we think people are going to claim or what they haven't claimed. We should estimate it conservatively based on what we believe people are entitled to claim. And we should never operate with the intent of saying, oh, well, people don't know any better. This is what we think we're going to be able to get from them. We should operate from the position of, this is what the situation is, this is what we're informing our people their rights and entitlements are, and this is what we expect the budget numbers are going to be. So that question, I think, would be better posed to the Department of Administration or BBMR as to whether or not they factored this in with the intent of determining the budget based on the lack of awareness of our people, or whether or not they factored it in based on whether they believed our people were going to be able to claim these exemptions and that the numbers reflected those claims. I, for one, would hope that our government would have been more conservative and based it on what we believe our people would have been able to claim, because we should never bring in more tax dollars on the backs of the ignorance of our people. We should be informing of our people of what their rights are and allowing them to fully avail of those before we begin counting our dollars and cents. So with respect to that question of whether or not it was factored into the budget, I'm not quite sure if the estimates were based on those figures, but I do know that I would have preferred a more conservative figure on the overall budget altogether, and I don't believe that we should punish our people or try to extract more tax dollars from our people based on their lack of awareness by not extending this deadline to December 31st. And if the government needs to go back and remedy the people by informing them and remedy the budget by adjusting those numbers down, that is the right thing to do. Thank you, Madam Speaker.
Senator, you still have the floor, and legal counsel is doing the research, so maybe what we'll do is take a recess, a brief recess. While we get more information, we're going to go ahead and recess for lunch until, but please be back at 1:30. I know the usual is 2, but it'll be 1:30. Okay, we are in recess until 1:30.